Stories that make a difference. Join Sam Marshall on the Social Impact Show. Weekdays 9 to 12 on 919 FM.
We continue our conversations here on the Social Impact Show, Mondays to Fridays, 9 to 12. On the line, I'm joined by Dr. Zakeera Docrat, a leading forensic linguist and postdoctoral research fellow at the University of the Western Cape, following the historic International Association for Forensic Linguistics conference hosted for the first time in Africa. Dr. Docrat reflects on Chief Justice Mandisa Maya's powerful call to reconsider English as the sole language of record in South African courts. As a champion for multilingual justice, Dr. Docrat shares what this could mean for access to justice and how the academic and legal sectors are coming together to transform the system. Doctor, thank you for joining me. Really appreciate it.
Good morning, Sam, and thank you for having me on the show, and good morning to the listeners.
Yeah, so before we unpack that, maybe if you could just, Doc, reflect for us on, you were part of the organizing team for this groundbreaking conference. Why was it so important, so significant to host it in Africa and specifically in South Africa?
Yes, thank you, Sam. This is the first time, as you mentioned, that the biennial conference of the International Association for Forensic and Legal Linguistics was hosted on the African continent. And I think it was even more special that as South Africans, we got to host it. The host institution was the University of the Western Cape. And, Sam, this is the 17th biennial conference. So, I mean, if you look at the number of conferences that have taken place so far, those have primarily been hosted in Europe. And for a jurisdiction such as South Africa, who has so many languages and we're so multilingual and multicultural, I mean, our access to justice is hindered. And I know we're going to unpack that later in the show by the use of languages other than English. So it was a real privilege to host it in South Africa and actually put the South African and African perspective forward on the challenges that we face, but also that the solutions that we've come up with.
Yeah, which leads to that call by Chief Justice, the call to revisit the 2017 directive, making English the sole language of record in courts. What makes this moment so pivotal if you consider that Section 6 of the Constitution recognizes 11 official languages?
Look, Sam, Section 6 is a fantastic provision in our Constitution. I mean, it reads well, it sounds very nice, but when it comes to practice, we know that the official languages are not used equally in many spaces, but specifically within the legal system. And I mean, the focus of late on English only has hindered access to justice. And unfortunately, the spotlight has not been shone on these specific issues, especially from the judiciary. So to have had the Chief Justice, first of all, come and address our conference, which was a great honor, and speak to around 180 delegates who we had in attendance, the majority of whom were international. But also to have the Chief Justice speaking specifically to the language of record issue and the impact that this has within courtroom discourse. I think, Sam, for a very long time, the academic voice and the judiciary, perhaps from a point of practice, have been speaking past each other. And it's very easy for us as academics to actually criticize what the judiciary is doing or the lack thereof, but not actually know the challenges within the judiciary, what they are facing. And the Chief Justice came, Sam, and she spoke very openly and honestly. And I think that must be credited. She must be credited, first of all, for being able to do that and taking that bold step. A lot of people asked her afterwards, so what are you actually going to do about it? Is it going to change within the next year or so? And she was very honest about the challenges that she faces as the Chief Justice in the country and as the heads of court. And, not only from a resource perspective, but also finding a policy that works best. We wouldn't want to open the floodgates where suddenly, people are accessing the justice system and demanding that we proceed in the language of their mother tongue or their choice. And obviously that might not be practicable in this specific cases. So she highlighted specific changes that could happen incrementally.
Yeah.
And as part of that, Sam, she said, for the moment, given that we have this English-only language of record policy, which is extremely unfortunate, and that those were actual words. We need to find ways around that while we work on revising that policy. And by finding ways, she said, specifically what she has done and led by example, writing bilingually. So encouraging judges to write bilingually where their mother tongue is not English. So you maintain that English, the international language per se, for the law reports and access, but then also give meaning to the African indigenous languages within South Africa. And that in turn, as she said, creates terminology development, something which perhaps lacks in some of our indigenous languages. And then finding other smaller spaces of collaborating with academics and specific people within the legal system, so your interpreters, your court intermediaries, focusing on those legal actors within the system and saying, what are the challenges that you are facing? What solutions could we assist? And all that really, Sam, leads to to revising the monolingual language of record policy. We cannot just revise that policy and say tomorrow, okay, we can proceed in languages other than English, where we don't have judicial officers who can speak languages other than English. We don't have prosecutors, attorneys, court intermediaries, and enough interpreters to support a decision of that nature.
Doc, I want to pick up one of the little breadcrumbs you dropped for us. If Chief Justice is saying that the official documents would be in English and then there would be potential translation into the other languages. And I think that is such a practical solve. But at the same time, we're talking about constraints that the system is facing. And that in itself, then, for me, would be such a great thing if there were the resources to accommodate that. But then at the same time, and I'll come back to the practical implications for somebody who is in the legal process and their first language is not English, because I know you're leading the research on this. But I just wanted to quickly pick up on that one breadcrumb. Are you then saying, or are we potentially then saying that AI with its large language models will then be able to, maybe technology could help bridge that gap if one of the solves are that on record it's English, but we could use another language in terms of the distribution of outcomes or whatever that legal document or framework looks like? Is that what we're potentially saying, Doctor?
Thank you, Sam. Look, with regards to the question you're raising about resources, this is one of the specifics that the Chief Justice mentioned and said, look, from a financial perspective, excuse me, the resources are strained. So, as you know, it takes a lot of money to pour into translation services.
Yes.
But as the academic voice, we are offering our assistance. And this is,
great.
I think, what was so important, to have this conversation, openly with the Chief Justice at the conference, publicly, to say, as the academic voice, we can assist where judges want to write bilingually. So, for instance, you saw Justice Meyer writing isiXhosa in English in that groundbreaking judgment. It's happening in the Western Cape High Court with the JP writing there as well, the new JP. So this is happening. I think what the judges need is support from academia. And as the academics now, as a consolidated voice coming out of this conference, we're saying this is something we can assist with ensuring the translation is valid. So we have the production of these bilingual judgments. So that's one thing to get around the resources aspect. But also from our side, Sam, in producing students from translation studies who can eventually feed into the system, and this is happening, who can give effect to actually be stationed in specific courts to assist judges to write bilingually. And that sort of counters the financial resource implication.
Yeah. And would that be, Doctor, would that be a solve in the next 6 months to a year, or would you have to pilot something like that to see what the practical implication in terms of the delivery of judgment and in terms of the speed of that output? So you would need to kind of pilot this, or is it much simpler than that?
No, I think that's exactly it. It would need to be piloted, and we'd have to look specifically at a province and maybe a specific high court, and then roll it out across provinces if it works. I think, Sam, in South Africa, we're all guilty of implementing a policy, drafting it, then implementing it, and when the policy fails, we throw our hands up and we say, okay, we tried. But but in this instance, we can't do this. And I think, we've reached the first step now where we've got the research, and I think we're actually at the second step where the Chief Justice is willing to look at alternatives or find spaces. So I think it's a major achievement for one. That's my personal view. And I wouldn't describe a timeline. But
Okay.
I do think we can't keep on talking about it, Sam. If we're still having this conversation, you and I, in the next 2 years, then I think we failed. We haven't done anything. So I think within a year or two, we should be starting to see some sort of progress. And within the next 10 years, have a fully fledged framework that is working sufficiently, perhaps within our court system. That would be the ideal.
Is part of that change, Doctor? And I don't know what the implication is because you're the expert here, so I'm just asking a question. And if it's silly, please forgive me, but I'm going to ask this question anyway. Would part of it be that you would also have to actually look at the 2017 policy shift, that directive that was issued, the directive that made English the sole language of record? Would that also need to be struck down or discarded in order for you to see some of these changes? Because I would only assume that while the policy stands, you might find certain institutions or certain departments might not be so eager to add what they might consider an extra challenge or an extra burden.
Definitely, I completely agree with you, Sam. The starting point is that 2017 policy, and that was acknowledged by the Chief Justice within a keynote at the conference. But for me, it's not really about just scrapping the policy, because then we don't have a policy to guide us, and that would create chaos. So we need to look strategically at how do we revise the policy. But my personal view, and this has been put forward through the research which the Chief Justice is well aware of, is having a policy, a language of record policy per province, rather than one nationally.
Yeah, that's
Our
very clever.
language demographics differ. So you're sitting in Gauteng at the moment. That is the most multilingual province that we have. I'm sitting in Makanda in the Eastern Cape, and here we have 3 dominant languages. So it's completely, it's more
Yes.
easy in a sense.
It has to be
But we
reflective, yeah.
exactly. And language is not a static practice, as we know, with migration and so forth. So we also need to take account of the statistics, and that's why the language planning process and the forensic and legal linguistics aspects of this planning needs to be undertaken. When the 2017 policy was taken, it was a top-down decision. None of us were informed. None of us were consulted, and I think that's where we went wrong. A policy of this nature, which affects ordinary South Africans, must be informed by the practices on the ground. It must be informed by the research that has been undertaken. And I think once we are able to do that in revising the policy, then we will slowly start to see positive changes for ordinary South Africans.
And I can only imagine then, Doctor, as a lead researcher and somebody who's championing this, that it could all be potentially summed up that access to justice cannot exist without linguistic justice. Is that a fair thing to say?
Oh, that is 100% accurate. And I think, Sam, that is something that came out of our conference from our other keynote speakers as well, who are primarily international. I think, even the 5 panels that we had, Sam, talking to various aspects of courtroom discourse, legal interpretation and education, translation, gender-based violence, sex crimes, vulnerable witnesses, hate speech, hate crimes, police investigations, and statement taking. All those aspects fed into each other and actually, were relevant. Again, we weren't talking past each other for the first time. And it was very interesting to see the international jurisdictions learning from us and what we're doing in South Africa and us feeding off them as well. And I think that was beneficial too for the Chief Justice to look at other models that are perhaps similar to us and what they've done and what we should maybe be ignoring, not to repeat those types of mistakes, but also looking at what we could emulate. But going back, Sam, I think I missed your question about AI. And one of our other keynote speakers, Professor Tammy Gales, who's now the president of our international association, she actually spoke to this. How do we use AI to improve access to justice? And obviously, speaking from the American context, and they're also moving to an English-only policy now for courts, she acknowledged that AI is a fantastic strategic tool, but at the same time, in her presentation, highlighted, the need for human interaction and where
Yes.
AI fails us. And within the South African context, now I'm speaking specifically to our indigenous languages, I wouldn't go with AI just yet within courtroom discourse. I think that the interpreters have a pivotal role to play, and other legal actors. So for me, AI can be a supportive measure, perhaps moving forward. But at the moment, it needs the human touch to
Yeah.
say we need to ensure our judicial officers speak languages other than English. We need to ensure that's happening with our legal practitioners, and that our interpreters are properly trained to give effective services within courts, and that there's no shortage, especially with this English only policy.
So if I understand you, Doc, you're saying that AI and that types of technology can be an added value, but it can't be the primary tool.
That is correct. I think it can be a secondary tool, and I would hold off within courtroom discourse specifically. At the conference, my colleague and I, Dr. Annelies de Vries, we actually sort of launched a prototype, an app using AI to assist the police and what it could possibly look like. It's obviously in the infancy stages,
Yeah.
but that's at the beginning of the criminal justice system where you enter a police station. It's a little bit more difficult when you actually within courtroom discourse, because suddenly you have multiple actors speaking at the same time.
Yes.
There is sometimes more than one language at play where witnesses speak, multiple languages. So the interpreters in those instances are key, so as is the judicial officer. But it makes such a difference where the judicial officer, the prosecutor, and the defense attorney or advocate all speak the same language. You're suddenly not so heavily reliant on the interpreter. You're able to pick up perhaps issues with interpretation that have critical impacts, not only for criminal cases, but also in civil trials as well. So the advantages of using languages other than English are immense. And I think, with the Chief Justice highlighting specific cases as part of her keynote where languages other than English were used in your lower courts was fantastic, because that was her acknowledging that we can do it if we just, put the specific policy in place and the specific methods and approaches to achieving this.
Dr. Docrat, thank you very much for joining us and so eloquently positioning this. I think you've given us a lot of stuff to think about, especially the stuff as laymen that we don't think about. So to be honest with you, I've never thought of language as a barrier for somebody to receive a fair trial, and that the inability for the court system to be able to understand that and the knock-on effects. So thank you. My mind is totally blown. So thank you very much for spending time with us.
Thank you very much for the opportunity, Sam.
Yeah, so that's Dr. Zakeera Docrat, a leading forensic linguist and postdoctoral research fellow at the University of the Western Cape, talking to us about a historic International Association for Forensic Linguistics conference that was hosted for the first time in Africa, in South Africa. So whoop whoop to South Africa. But reflecting on the statements by the Chief Justice Mandisa Meyer's call to reconsider English as the sole language of record in South African courts. Wow, a lot to think about. And you can only imagine, if you're in a court system that doesn't reflect your first language, how challenging it might be to defend oneself. Okay, we're a couple of minutes away from the top of the hour news. I can see my colleague, my extraordinary partner. She's just walked in studio. We'll play a song. We're back after this.